Hello and welcome to Devil's Advocate and an exclusive special interview with one of the architects of the recent landmark 2G judgments, Justice Ashok Kumar Ganguly. Justice Ganguly, let me start with a comment made about your recent landmark sanctions judgment and 2G judgment, both of which were delivered in the last 30 days. The first was reserved in November 2010 and made public 13 months later. The second was reserved in March 2011 and delivered 11 months later. Both were delivered during an election campaign. And in some quarters, this has led to people being suspicious about the timing and the delay. How do you respond to that sort of comment?
Well, I understand that the judgment has to be delivered during my tenure, since I was a party to the judgment. I was retiring on 2nd of February 2012. That date can't be altered. So I thought that it is better to deliver the judgment than to keep it undelivered, because I can tell you, in my tenure as a judge of 18 years, I have not kept any judgment undelivered which were reserved by me. Now these two judgments were heard by a bench of Justice Singhvi and myself, but both the judgments were reserved by my learned senior colleague Justice Singhvi. I can tell you, if the judgments had been reserved by me, they would have been delivered long ago.
So in other words, the reservation was not done by you, it was done by your brother judge?
Senior brother judge, yes.
And you were determined to deliver it before you retired?
Yes, otherwise it would have been a huge loss of time, because these cases can't be dismissed off the cuff. These cases were heard, at least more than 30 hearing days were devoted. So again, when the judicial time is so precious, I would have felt very sad, and people would have criticized the system if these judgments were not delivered.
So the suspicion in some quarters about the delay or the timing is unwarranted?
Absolutely.
And the delay, if there was any, was only because your fellow judge, your senior fellow judge, wanted to reserve it for a while?
Yes, the judges are under tremendous pressure, especially in Supreme Court. You see, so as a result of this pressure, it must have been delayed.
Now,
I'm sure the delay is not intentional.
Now, one of the important judgments was the 2G judgment, where you found that first come, first serve is fundamentally flawed. You believe it's a violation of constitutional principles, and you say when it comes to alienation of scarce natural resources, the state must always adopt a method of auction. Are you prepared to accept any exceptions to that rule? Is there any room for discretion?
First of all, let me tell you that I am not here to defend the judgment.
Absolutely. I'm only asking for explanations. I'm not asking you to defend it.
I'll tell you. The judgment is fairly a reasoned one. The reasons are all there. So, but there are no, of course, you're right and true that there are no such absolute propositions. All propositions have to be considered in the facts of the case. In the facts of the case which were discussed in the judgment, we thought that that is the only viable option.
So, is the ruling that the state must always adopt a method of auction a ruling that should apply to all natural resources?
I can't say that, because it has been said in the context of the facts considered in the judgment.
So this is in the context of spectrum?
Yes.
It is possible, therefore, that in the context of other scarce natural resources, for instance water or land for hospitals and schools, auction may not necessarily be the best way of handling those.
Well, I am not here to sort of predict on those lines, but it all depends on the facts. Normally the lands which are for hospitals and schools are acquired under the Land Acquisition Act, normally, the procedure in our country.
So auction doesn't apply there?
Naturally.
So there is in fact room for discretion, because this is an issue that many people have asked themselves, is there room for discretion, or is this an inflexible rule, a rigid principle? You're suggesting to me that there is clearly room for discretion. Each case is a case on its own.
Yes, discretion, as you know, is the lifeblood of any judicial decision. There can't be any if I may say so, any straight jacket.
So people who threw up their hands in the air and said, oh dear, this judgment has laid down an inflexible rule, all natural resources have to be auctioned, there's no room for discretion hereafter. Those people have misunderstood the judgment somewhat.
Well, I don't know, but you see, a judgment has to be understood, as I'm telling you repeatedly, has to be understood the facts which are discussed and decided in the case.
And it has to be understood in the context of the case.
Of course.
Now, a second concern that's been expressed, and you must have heard this and read it in the papers, is that your judgment has found that Mr. Raja behaved wholly arbitrarily and unconstitutionally. And people say, in effect, Justice Ganguly and Justice Singhvi have tried and found Mr. Raja guilty, although he wasn't in front of them and he wasn't being defended. And people say, this is unfair, this looks like a miscarriage of justice.
Well, we don't think so. There is a trial going on. In the trial, he is getting all the opportunities to prove his innocence. But here we are considering the matter on the question of an executive decision. The decisions which were taken, the decision of the minister concerned was defended by the government. So it's nothing personal.
So when you say that
it was a decision of the government. And he happened to be the minister, so therefore he was defended.
How was he defended?
Because the ministry was defended. He acted as the minister, and the ministry was defended.
So you're saying the government's lawyers who appeared before you would have been defending Mr. Raja's actions, that would have been his defense?
Yes.
Except that the same government is prosecuting him, so Mr. Raja wouldn't consider that the government was defending him in one instance.
It was open to him to come and defend himself if he wanted to.
He had that option?
Of course he had.
You're saying that
the court never shut out anybody.
So if he wanted to, he could have exercised that option. That was up to him to decide.
Yes.
I know your judgment ends in the last paragraph by saying that nothing in the judgment in any manner shall prejudice the defense of those who are facing prosecution.
That's right.
But are you absolutely confident that the trial court won't be influenced by what is, at the end of the day, a strong and unequivocal finding of guilt against Mr. Raja?
Certainly, certainly. The court is a court. Therefore, we made it clear that these findings are for the purpose of looking into the official business. The criminal case is slightly different. It goes on a different perspective. And that is the penny. He is entitled to get his defense.
Except the trial court judge is a junior judge. Two Supreme Court judges right at the top of the chain have given
there is
a
nothing
verdict.
What is called junior or senior. He is doing his duty. He is doing every judge is independent of anything. And we made that clear by saying that this will not affect.
So you're really confident that this won't affect and prejudice Mr. Raja's case?
No, it cannot. That is how the judiciary functions.
But people who turn around and say, and you must have read this, that you virtually decided the lower court trial as well, are being unfair to you.
No. I don't think so. The trial is an independent trial. And after the trial, he has all the further opportunities of going higher up.
So you are confident that you haven't prejudiced Mr. Raja's trial at the lower court?
Certainly not.
Now, your judgment, and this is another concern that has arisen in the papers, it's a concern that worries the telecom sector in particular, has struck down licenses awarded by first come first serve post January 2008. But you said nothing about licenses awarded in the same way between 2001 and 2007 because, as your judgment says, they were not party to the petition before you and their legality wasn't being questioned. But doesn't it also therefore follow that the legality of those judgments remains unresolved?
I mean, things which are not challenged before the court. Again, you are asking me on the merits of the judgment. I don't want to say.
I'm only asking you to explain what the position is regarding these earlier licenses.
I'll tell you. What has been explained in the judgment has been explained in the judgment. I'm not in an interview. I'm not going to do it any further. I'm not going to defend the judgment. The judgment stands as it is. But I tell you that every judgment has a territory. Things which were before the courts were considered. Things which were not before the courts were not considered.
And the licenses awarded by first come first serve between 2001 and 2007 weren't before you and therefore weren't considered by you.
Precisely so.
If today or tomorrow someone were to bring a petition to the Supreme Court questioning the legality of first come first serve licenses awarded between 2001 and 2007, do you believe the Supreme Court would entertain that petition?
Well, I can't predict.
But what's your feeling?
I can't make any comment on something which may happen in future.
If the Supreme Court were to accept such a petition, does it not follow that to be consistent, it would have to apply the logic you've applied all the way back to 2001?
Well, what logic will be applied in a given situation in a future litigation? It's a very hypothetical question, and I don't want to answer that.
Except that if the same logic wasn't applied, then the Supreme Court would be applying two different standards, one to licenses post 2008 and another to licenses pre 2008. That would be inconsistent.
I don't know. I hope and believe Supreme Court won't be inconsistent. But on a future litigation, it's not for me to make any comment.
I understand. You can't make a comment on future litigation, but equally you've said that you hope and pray that the Supreme Court won't be inconsistent.
Yes, certainly. No court is, it is expected that the court won't be inconsistent.
And to be consistent, the Supreme Court would have to apply the logic and conclusion of your judgment to any future petition as well.
There I am very guarded in my reply that I cannot say what the Supreme Court will do in a future litigation.
Except that consistency would require that they apply the same principle and the same logic.
I do not know. Consistency is a word of very wide import.
All right, you're leaving that open, and this I raised only because it was an issue that concerns not just the media, not just license holders, but the telecom sector. Would I therefore be right in concluding in this way, that as far as licenses issued on first come first serve between 2001 and 2007 are concerned, there are question marks about them, and those question marks will only be resolved when a petition is brought to the Supreme Court and it addresses itself. Until such time, uncertainty will continue.
I don't know what is uncertainty. If the licenses are not questioned, the licenses remain.
But when they are questioned, uncertainty will arise.
And then again, we are talking of future. On that, I don't want to answer.
Now, your judgment has had a serious impact on the foreign companies such as Etisalat, Telenor and Sistema, all of whom have invested billions of dollars in legitimate contracts through government procedures agreed by the government and with government permission and approval. Suddenly, these people find that their contracts are in jeopardy. Does it worry you that they might now feel a need to go to court and challenge your judgment?
Maybe. I can't say anything. What is the rights? If anybody feels that their rights have not been protected, it's for them to decide.
But if there is a plethora of challenges, would that raise question marks about your judgment?
I don't know. I am not here to certify my judgment. My judgment, it's not my judgment, it's a court's judgment. The judgment of the court. For whatever it is worth, it's worth. I'm not here to certify that.
A second issue that's arisen in the press is, has your judgment created doubt in the minds of potential foreign investors who now, before they come to India, might say to themselves, given that sacrosanct contracts can be overnight negated, should we be going to India? Have you created doubts in the minds of potential investors about the viability of investing in India?
We don't know. This is not the first time that a contract is quashed by courts. This is nothing new. There are very many aspects of a contract. I'm not talking of this particular judgment. It has happened in the past. It might happen in the future also. That every contract has certain parameters, legal parameters. Whenever anybody comes and for entering into a contract in this country, the law of the land has to be obeyed.
So are you saying to me that foreign investors should be reassured that ultimately the rule of law and transparency will prevail and wrongdoing will be rectified, rather than worried by the fact that 3 individual companies who believed they had sacrosanct contracts might have suffered?
I would like to think that way, but I am not, again I am telling you, again what is going to be the fate of those, of any foreign investors in future, it will depend on future mode of contract and the legal implications.
Justice Ganguly, let's take a break at that point. When we come back, I want to talk to you about your other landmark judgment, the sanctions judgment. That's in a moment's time. Don't go away. Welcome back to Devil's Advocate and an exclusive interview with one of the architects of the landmark 2G judgments, Justice Ashok Kumar Ganguly. Let's come briefly, Justice Ganguly, to your sanction judgment, which gives the government a maximum of 4 months to respond to corruption complaints against public servants. Now, critics turn around and say that wittingly or unwittingly, you may have opened a Pandora's box for spiteful and vengeful complaints, which will end up harassing individual and innocent people rather than furthering justice.
Well, every judgment is open to criticism. I don't say that no judgment is just can't be criticized, but we have given reasons why we are. Those are the suggestions given by the court, because as at present advice under the Act, Prevention of Corruption Act, I think section 19, where they have to ask for sanction. Time limit is not fixed. So we have said the government should do well to follow this timeline in order to have corruption-free governance.
How do you reconcile the fact that you've given the government a 4-month timeline in which to respond to corruption complaints against public servants, but there's absolutely no time bar when the Chief Justice is approached for permission to file an FIR against a sitting judge? To be consistent, shouldn't there be a time bar in that instance as well?
Well, I don't want to say anything, but as far as the directions or the recommendation, these are not said directions, these are recommendations are concerned, they should apply across the board.
They should apply across the board?
Yes. We have not made any. In our recommendations, that is not legislation. Kindly understand the difference.
That is practice and convention.
Yes, we have suggested these by way of recommendation to the government to consider this and make an amendment to the law.
But you're also suggesting or hinting that the same recommendation should be borne in mind by the Chief Justice when he's considering
I do not
a request for an FIR.
I am not making in reference to any particular person or any particular authority.
But it should apply across the board.
It should apply across the board.
That is a very important thing you're saying. I don't want to embarrass you by making it too explicit, but the recommendation should apply across the board.
That's our views.
Now, in this particular judgment, you've made a distinction between the PMO and the PM. Most people turn around and say that this is an invalid distinction. They say that this distinction looks as if it's an attempt to exculpate the Prime Minister from any wrongdoing by pinning the blame on his juniors and his subordinates, whereas at the end of the day, as head of the PMO, he carries responsibility.
Yes, certainly he does carry the responsibility, but we have made a distinction considering the onerous duties of the PM and considering the fact that in the particular facts of the case, there were queries made by the PM himself, but he was not properly assisted by his office.
So the fact that he made queries permits you to make this distinction?
Yes, again in the facts of the case.
This doesn't mean that a similar distinction will be made in other cases. Those other cases will stand on other facts.
You understand the business, the heavy business which the PM has to discharge. Considering that, and considering the fact that he made queries which are not properly answered, therefore we have made this distinction.
Now, my last question, in the 2G judgment, it appears that you've pinned the blame almost entirely on Mr. Raja, but you haven't paid sufficient heed to the principle of collective cabinet responsibility. Surely, such a momentous decision requires that the cabinet also accept responsibility.
I think from the judgment, if you look at the judgment facts properly, you will find that the minister concerned did not pay heed to the requests made by other ministers, including the request made by the law minister to put the matter before the empowered committee.
As a result of which collective cabinet responsibility, you're saying, doesn't apply?
In a way, yes, because that is why we find that there is no proper policy.
What about the fact that in the 3 areas where Mr. Raja is found to have acted wrongly, pricing, advancing the cutoff date, determining first come first serve in terms of letter of intent rather than in terms of date of application, he either informed the Prime Minister and the Prime Minister overlooked it or ignored it, or the Prime Minister gave him advice which Mr. Raja overlooked and the Prime Minister didn't monitor. Doesn't that point the finger all the way to the PM?
Now, you are again asking me on the nitty-gritty of the judgment. So they are all discussed there, but I don't want to go over them again in an interview.
But you're absolutely convinced that in this instance, the principle of collective cabinet responsibility does not apply.
Possibly that is not followed.
It doesn't apply.
It was not followed in this particular case.
It wasn't followed. Raja acted unilaterally, which is why his colleagues in cabinet don't share any blame.
Possibly, yes.
Justice Ganguly, thank you very much.